Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. Ann and I are here. Ann Lipton, a law professor at the University of Colorado, I get to say that now, who teaches and researches securities and business law. She holds up the legal end of this podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Yes. So let's plunge right into our favorite case study, which would be Tesla, of course. It's been a little bit since we've talked about it.
Corporate governance hot mess.
Yeah, hot mess. Oh, good. Corporate governance hot mess. I hadn't thought about it that way. Which has become our favorite kind of punching bag for corporate governance problems. And there's some this week. Some just happened. So we can talk about that news and review what happened there. Before we get into that, let's talk about our mailbag. Ann, if you want to mention that.
Absolutely. So we have an email address. We mention this a lot, shareholderprimacy@freefloat.llc. We read the emails, we get through them slowly.
Yes,
but we
gradually.
are getting through them. So if there's something that you would like us to talk about or just a simple question that you'd like us to answer, you can email us at shareholderprimacy, one word, @freefloat, one word, .llc.
Perfect. All right, let's get to Tesla. And I always, there's some trepidation and then always some eagerness, at least on my end, about.
Yeah, so Tesla's having some fun with its annual meeting.
Right, AGM, annual. Let's talk about that for a second. I've tried to change the nomenclature, make it annual shareholder meeting. AGM is, I believe that's a European phrase. Annual general meeting. General meeting. AGM, and everybody here uses it, so we'll call it the AGM rather than the ASM. Anyway, their ASM or AGM was announced last week to be scheduled for November 6th of this year. And so they basically just put out an 8K and said annual meeting is coming up. They didn't put in any kind of proxy statement yet. Of course not. They just sort of said, here's the date. And that came on the heels of a couple of little developments. First, and most importantly, a bunch of big pension funds, like state pension funds, wrote them a letter saying you haven't scheduled it yet, and we'll talk about that timing in a little bit. But we really need you to schedule one. And they kind of reiterated all the standard bill of particulars and complaints about corporate governance, and the board needs to be responsive, stuff we've talked about endlessly. Anyway, so they wrote this big letter. And the New York Times. Go ahead.
The New York. You were saying the New York Times picked it up because just as a basic matter, corporate law, any state's corporate law requires an annual meeting to do some basic stuff. The most important of which is to elect directors. You might have now. Tesla's a classified board, so not all the directors are up for election every year, but some are, and so you're supposed to have an annual meeting.
Right, and they hadn't, which again we'll talk about that in a minute. And so the New York Times their headline was, "Will Tesla break the law?"
What a thing to wonder about.
Imagine that Tesla violating some sort of corporate governance, corporate law statute, probably in Texas at this point, or SEC rule or something like that. And we'll talk about that in a minute. So in response, and we can talk about the nature of that response in a second, it said it would convene the AGM. It did not set a record date yet. So people, you want to invest in Tesla and vote at the AGM, you still got a chance. So you could do that.
They can backdate record dates, though. I think they could suddenly come out and say, actually, the record date was yesterday, and so you can't.
Yeah,
I mean, there are some rules about how far in advance of the meeting it has to be, though.
Right. So I suppose if they wanted to, they could set a record date for like this past April, and then
as long as it's going to have to comply with something about there are often rules about whether or not the record date can be too far out from the actual meeting. All
right. But so anyway, so November 6th got us thinking. Well, it got me thinking and us thinking about sort of the history of Tesla AGMs and so forth, and we'll talk about some of the implications and why November and why not December or October or some other date in a little while. But just to kind of look at Tesla's history, this should surprise nobody. Until 2019, like any kind of normal company with like a fiscal year end of December 31st, their annual meetings were always in like May or really June. And just, for years. Tesla's been a public company for at least 10 years before that. So they always had June annual meetings. And then in 2020, it was July. And then in 2021, they moved it to October.
So they're just moving it around.
Yeah, moving around. October 2022, it was in August. And then there were a couple interesting kind of situations. So in 2023, they made it as the earliest it's ever been, May 16th, 2023. And they did something very sneaky that year. And some folks might remember that, is that they had announced the date and the I don't remember the record date, but they announced the date for the AGM in like a tiny little corner of a 10Q for the third quarter of 2022. Said, here's our date. Nobody saw it. Okay, so nobody figured it out until like the deadlines for submitting 14A8 precatory proposals and director nominations had long passed.
Right. So they hid when the shareholder meeting was going to be, so that shareholders couldn't put stuff on the agenda.
You're right. They didn't exactly hide it, but they certainly did make it obvious.
That's hiding it.
Okay. So in 2021, they had gotten 8 precatory proposals. In 2022, they had 8 of them. In 2021, they had 5 of them. So for 2023, they had a grand total of 1 proposal. So somehow that was anti-proposal year. So they didn't want proposals for 2023. So that succeeded. And I remember everyone in the ESG community was complaining and scrambling around and thinking of suing them. You can't. I mean, it was done. Right. So 2024, last year, of course, was a really big meeting because they had a couple of items to vote on that was of interest to them rather than to shareholders, which, of course, was the shareholder vote to move their corporate domicile to Texas, and also the crazy vote to ratify the equity grant going back to 2018.
Yeah, which McCormick ultimately said that
right, it's not going to work, but they tried. Right, and we'll actually maybe touch on that a little later. But importantly, why June? Rather than like May or something like that. I kind of guessed at the time they had a bit of a dilemma. On the one hand, they wanted to kind of schedule it, pretty fast so they could get this out of the way. On the other hand, those were going to be 2 significant matters where they had to really turn out the vote. If you remember, Musk was like giving out factory tours. Was really
it was going to be like I think it was like a raffle for a tour of the factory.
Yeah, right, exactly. So because the voting standards for those 2 were somewhat higher than earlier kind of votes. So I was guessing, at least myself, I was guessing that they gave themselves another month to do that. But they scheduled it just within the 13-month deadline, which we're going to talk about in a second, to have the meeting, so they didn't need to reopen notice periods and so forth. So that's what happened in 23, 24. So the idea of the 2025 meeting not happening and then moving out to November, again, just based on the history, was kind of predictable. But then we can sort of dig into the why November. But we'll do that in a second.
So they had shareholders who were saying, where the hell is this meeting?
Yes, correct. And the theme of at least the New York Times headline and so forth was you needed to schedule it and you're about to pass the deadline. And so that gets to this interesting little artifact. I think this is common in most states, require a public company to have a meeting within 13 months of the last one. I know that's the case in Delaware, right? And that is also the case in
apparently
Texas.
I think it is also the case.
That's in Texas.
I guess we'll all have to become experts in Texas
law. In Texas corporate law, right? Exactly,
yeah.
Right. So I looked it up. Section 21.351 of the Texas Corporation Law, I can't remember the full name of it, requires a public company to convene an AGM in 13 months. And like I said, Section 211 of DGCL, the Delaware corporate law, also is the same thing. And so, but for them to kind of break the law, I mean, there was some chatter on socials among us governance junkies about it's going to happen to them. Well, the penalty for failing to schedule an AGM is you got to schedule it. There's no fines. There's no one's going to prison for this. They're going to compel it. And so But importantly, nobody in any state Secretary of State's office in Delaware or for sure Texas is sitting around waiting for these deadlines to pass. It's not like your car is kind of parked and there's and once the timing on your meter passes, there's some parking enforcement person kind of jumps out and writes you the ticket. No one's waiting to kind of haul, to compel Tesla to have the meeting. A shareholder's got to demand it.
It's like fiduciary obligations. It's not enforced by the state. It's shareholders.
Very good. Yeah, that's exactly the point. So we were kind of guessing that in particular, the signatories on the letter, which was the Illinois State Treasurer, there was some pretty interested and potentially litigious signatories to that letter. So if Tesla may have been thinking about this for a while, but once that letter came out, I'm guessing they had to say, okay, either we do this or they're going to force us to do this.
Yeah. So they finally came out with a date.
Right. So,
which is quite a bit later than.
Right. But in terms, let's talk about that for a second. In terms of the scheduling, if the state treasurer were to, Illinois State Treasurer Michael Frerichs, who's a guy we know here, were to say, okay, no crickets from Tesla about this meeting, I'm going to sue him. And they go to Texas court, and Texas court, you're right. I mean, there's very little defense, I don't think. Mm-hmm. Yeah. If you haven't done it, they're going to, and I mean, the facts are, I haven't done it, it's 13 months, so you've got to do it, right?
Yeah. I mean, it's fine. I mean, I don't know. Like, it seems pretty obvious to me. You've got to hold your shareholder meeting because shareholders have a right to vote on directors.
Exactly, right. But in terms of the actual scheduling, my sense is, and I'm actually involved now in an activist situation where we are compelling a portfolio company to hold an annual meeting. It's much smaller, it's obviously not Tesla. And the mechanics are, they don't, there's sort of a reasonableness test, I guess, where they say, okay, you just need to hold it within like a reasonable period of time. Okay,
they're not going to drop everything and hold it.
Right, yeah, right.
You got to print a proxy. You've got to put items on it,
right. Et cetera. So like in this one other case I'm working on, it's been a while. It's been like almost 2 years since this company's had an annual meeting. So we know they could. So we're basically prepared to tell them, okay, you got to do this like within 45 days. Okay, that's kind of stretching it, and no one's going to tell Tesla. But on the other hand, if Tesla were to go to some magistrate in Texas and say, okay, we're working on it. It's in process. We got all these things we got to kind of put together for the meeting. Can we have like 4 months? Mm-hmm. I would imagine that magistrate would say, okay, cool. The
whole point of being in Texas was they expected a very friendly and forgiving court system.
And so they're not going to give them a year. They're not going to give them like tons of time. But so my estimate was that November was kind of the outer bounds of what they would be able to get from a friendly judge without their, getting into hot water with them. And I don't know how that sounds to you. That probably seems about right.
You would have a better sense than I do about like what a judge is likely to do in this situation. But yeah,
I guess. I mean, again, I've never sued anybody.
So you think they basically put about as late as they could possibly go before they were likely to get actually in trouble with a court.
Yes, right. And again, if some shareholder were to come in now and say, okay, we need it sooner than November. We have precatory proposals we need to submit on and vote on. That judge would say, no, especially in Texas.
Yeah.
They'd say, okay, Tesla's doing it. I don't know what you people want. And so they'd get it for November 6th. So, the deadlines are all now reset. So any followers here that already submitted your precatory proposals for Tesla or your director nominations, you got to do it all over again. Go change the dates, resubmit. The deadline now is July 31st. So anybody who hasn't, you got about two and a half weeks to write them up and submit them. The window opened for director nominations in non-14A8s, so that's July 9th to August 8th, so you got another couple weeks after that. So you can do it. If you want to elect or nominate directors, you need to hold your shares in registered names, so you got to register shares. You even have time to do that. So Tesla did open themselves up to more of this. I'm not sure Tesla really cares, but there's still time for that. Okay. So now that we've kind of set the stage, there's some really interesting questions about, what can shareholders look forward to voting on, and why wait till November?
Why the delay is really the critical question.
Right. Why don't we? What do you say we take a quick break and then cover all that stuff?
Okay.
In a moment.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. We've been talking about Tesla and how it finally got around to scheduling its annual general meeting. And the big question is, why? Why delay it until November 6th? I mean, it's been more than a year. Why not schedule it for July or September or October? It seems like they want to give themselves time for something.
For something. So
something that they're going to have to put on the proxy. So
right, and they're going to try to they're going to want to get all their ducks in a row to on some possibly some interesting matters. They're going to want some time to expose that to shareholders and probably get their support for various things. And then there's just the routine process with a company as big as complicated as Tesla to try to just line it all up. So so we thought of a couple of things that were kind of pending there. The one just was kind of disclosed in the past several days, which was potentially this investment in XAI. Now, just as a quick reminder, XAI, of course, is the artificial intelligence business that Musk owns, and is now the owner of the former Twitter business. Couple weeks, 2-3 weeks ago, they announced a new round.
Yeah.
I don't know if it's their D round or the F round or whatever round of investment, but they're raising $5 billion in the arms race to bring money in so they can compete with OpenAI and Anthropic and everybody else. And there was some rumor, so Tesla hasn't really made any kind of an announcement, though Musk has been tweeting about this. So that's semi-official, I guess. I don't know who's been monitoring his tweets lately, but
I don't think he has a Twitter.
I don't think there's any Twitters that are. And so potentially $2 billion out of that $5 billion round was going to come from Tesla.
No,
Tesla is sitting on
SpaceX.
Well, yeah, but earlier that was from
Tesla. Reported. SpaceX
right,
is going to definitely put $2 billion in.
Okay, maybe SpaceX will put $2 billion in, but potentially. The problem is that Tesla is sitting on this enormous mountain of cash. I don't know what SpaceX isn't public. We don't see SpaceX's cash situation. We don't know what kind of cash. And $2 billion is probably not much to either.
Well, he's used SpaceX as a cash as a repository before. He used it to buy Twitter. I think he actually bought.
Yeah, he's generating cash there. Anyway, so where it comes from is TBD. Again, there's been different accounts about whether. And maybe both Tesla and Tesla's done this stuff before.
Right. Yeah. So I mean, there's this possibility that he put out, I guess, on Twitter, as you say, that in addition to the SpaceX investment, which was reported, that he wants to have Tesla actually invest cash in XAI and buy a piece of XAI.
Right. And his well, go ahead. His tweet was, someone tweeted at him, "Oh, you're going to invest $2 billion." He says, "Yes, but it's subject to shareholder approval." That was the tweet from yesterday.
Yes, this is the tweet he just put out, that he would have a shareholder vote on it. So the first thing I have to just observe about this is he is being sued in Delaware. It's the case that was filed. It's been consolidated. There were cases. They were all consolidated. just before Tesla reincorporated into Texas, saying that XAI is a Tesla opportunity, that he essentially stole an asset of Tesla to create XAI in the first place, that this should have been all part of Tesla to begin with, and that's a breach of fiduciary duty, and shareholders are currently suing about that. And now he's saying that Tesla can have XAI back, but if it pays up. So
it's like, it feels like a little extortionate, but whatever.
Yeah, so I mean, we'll see what happens with the Delaware case, but... So that's pending before Chancellor McCormick in Delaware. But leaving aside that, there's this interesting little bit to his tweet, if you take the tweet seriously, which is that not only is he planning on proposing Tesla invest in XAI, but he's proposing to have a shareholder vote on it. Now, that part is interesting because it raises the question, well, why have a shareholder vote on it?
Yes.
Now, because this is, and now the answer, were this still a Delaware company, would be because it's a conflicted transaction. I mean, normally, if a company decides to make an investment in another company, we don't put that to a shareholder vote. That's a board of directors decision.
Right. There's no vote needed to cleanse it or whatever.
With cash, they can. That's what the board is for. They put cash into things. But we would consider this a conflicted transaction because it's Musk's on the board and investing in one of his companies. And as we've said many times, if we're thinking about Delaware law, that if a shareholder sues over a conflicted transaction, if there's a shareholder lawsuit, then it's subject to higher scrutiny by a court. It doesn't get business judgment deference. Conflict transactions are reviewed to see if they're entirely fair to the company.
Right.
But a company like Tesla can restore business judgment review if they insert an independent decision maker into the process, someone who isn't conflicted, like
shareholders.
So a shareholder vote to cleanse the transaction. But here's the thing. Tesla is not in Delaware anymore. That's Delaware law. Tesla's now in Texas. And remember, in Texas actually has a sort of similar rule to Delaware's. Conflict transactions get entire fairness review unless there's an independent decision maker. But Texas, in its effort to lure more corporations, recently added a bit to its corporate code that says if you are a public company, you are permitted to adopt a bylaw that says no one can bring a derivative lawsuit unless they hold 3% of the shares. And Tesla immediately took advantage of this.
So they amended. Right, I remember they amended their bylaws to conform to this and take advantage of this, whatever safe harbor or whatever it is.
If you want to sue Tesla over a conflict transaction, you have to have roughly $30 billion worth of Tesla shares. Nobody has that. Certainly, no one is going to bring a lawsuit.
Right. So I think there's one. There may be one shareholder left.
Oh, is there?
Who
I mean, I'm thinking of BlackRock and Vanguard, but
there's one I can't remember the guy's name. There's one independent shareholder.
Okay, then maybe there's one guy. But you could just ask him. You don't have to have a shareholder vote. Just ask him. Are you okay with it? Because right. So the thing is that they don't need to have a shareholder vote then to cleanse this deal. They don't need to do anything to cleanse it because there's no possibility of a shareholder lawsuit. So if he is planning on having a shareholder vote on this, that's voluntary. That's for the optics, but it's not. It's not like a legal. It's not going to be a legal requirement.
It's not going to be a defense against the conflict that this represents.
They can have as many uncleansed conflicts as they want now. There's simply not going to be an issue because nobody who has $30 billion is going to sue the company except apparently this one guy. But once again, they can just talk to him. I don't know the guy.
Right. So that's kind of a little bit of a puzzle. So either, and I always think that when we see tweets from CEO Musk, nothing's an accident.
Well,
so either there's something going on here that hasn't been disclosed or whatever, or maybe this was an accident. Maybe he just sort of said he was trying to little belt and suspenders it or something like that. He
may just really, he's not really running it by lawyers about what's necessary, and he really does prefer the optics of I'd have the shareholders.
Oh, sure. Okay.
It's not like the shareholders are going to vote no. But the interesting thing is once again, we have to fold it back to he is currently being sued in Delaware on the theory that he stole XAI. That's really the idea here, that XAI was a Tesla opportunity and he breached his fiduciary duties by taking it for himself and developing it in a separate company. So it's all very
all right. So beyond that one, there's also an expectation that there is potentially going to be another vote or a shareholder vote on a new equity grant.
Yeah.
So it would be presumably to replace the one that is pending
yes
to
and
take the
no.
Tornado one. But let's talk about that.
Yeah, so this is the company. See, I think that's it. I think that's what the delay is. I think it's over figuring out what to pay him. Because it actually, the problem is that it both is and isn't independent of the Tornado grant. So remember, that he got this grant in 2018, which ultimately would have been $56 billion worth of stock. It's worth more now if the grant goes through. But that was only supposed to pay him for like some period of years until he met these milestones. He has been working without a comp package since then. Now, we know the Delaware struck that package, but whether the Delaware court struck that package, and that issue is on appeal. The Delaware Supreme Court will or will not overturn Chancellor McCormick and will or will not restore this original grant. But no matter what it does, he still, apparently wants like new compensation, which is not unreasonable, he said before, a new compensation package on a go-forward basis.
Right.
So the board has to come up with a new compensation package on a go-forward basis, but they have to do that without knowing what the Delaware Supreme Court's going to do about the old compensation package.
Right.
And this is presumably relevant information because there's no, I mean, all the briefings in on that Delaware Supreme Court case, but they haven't scheduled even oral argument yet. I mean, there's no chance that it will be decided.
We are not, Tesla shareholders, of which I am one, will not know when I go virtually to the November 6th AGM, we will not, there's no way we're going to know the fate of the Tornado, call it the Tornado package.
Yeah, but maybe if they've held oral argument and there were hints at the oral argument, but otherwise.
Sure. Yeah, we could kind of guess.
But not really, So this board, I mean, I think it's actually really complicated for this board, both like legitimately and also part of the issue with the board power relative to Elon Musk. Like on the one hand, there really is a question of whether he's going to get that money back. And that matters. I mean, if I were Musk, I mean, a thing Musk could do quite legitimately is say something like, if I don't get that restored, then as a condition of my continuing to work at the company, I want something similar just awarded me, like a bonus for staying, given that I didn't get my old money. Now, that's difficult for Tesla to do financially, like, because we've talked about this before.
Oh yeah, right. The
Tesla
accounting hit from that is gonna kill him.
Yeah, I mean, Tesla deciding financially to award him that much stock, just free and clear now, is like the signing bonus for his going forward. They can do it legally, but it's a huge accounting hit. It's a huge tax hit. I mean, it's terrible for them. But they have to figure out whether they need to somehow compensate him for that loss for his going forward. It's not a question of restoring it. It would be like, Elon, as a condition of working at the company, we are going to restore to you that some degree of the pay package that was struck, except they don't know whether they need to.
Right.
But the other issue is, how do you design, like, what are the goals for this compensation package going forward?
Oh,
He's not, right? I mean, like, what are they going to ask? I mean, on the one hand, they're in no way going to ask for stock price increases similar to what the old one was. The old one was he had to, like, multiply it, like, by 12 times or something.
Right,
They're not going to ask for a 12-fold increase in Tesla's market cap. So, but at the same time, we know what this board wants, even if they can't demand it, right? What would you want? Which is, stay out of politics. Stop it with this. Create a party.
Right.
Work at Tesla.
Focus on Tesla and not on Boring Company and Neuralink and all that. Yeah, right.
Exactly. And the thing is that for me, like, leaving aside the whole issue of what you do about not knowing whether the old pay package is going to be restored, I view whatever compensation package they come up with going forward as like the ultimate test of whether this board has any control over Elon Musk at all. Like, is it going to be a meaningful constraint? Like, you get paid, but you have to actually do something that you might not otherwise do, which is to say, stop it with the politics and all of this.
So let's bring this back to the November AGM. Whatever that board, however the board squares that circle, threads that needle, figures out, what kind of pay package makes sense for this unique individual, this unique executive, they're undoubtedly going to want shareholders to.
They have to get it, but here's the thing: is the why they have to get it.
Okay,
because we just said a conflict transaction would need to be cleansed if they feared a shareholder lawsuit. Now, this is a conflict transaction. Musk is on the board. His brother is on the board. If they're awarding him pay, that is a conflict transaction.
Even in Texas. Even in
Texas, it's a conflict transaction, and it needs independent approval. Now, we saw The last time it was invalidated in Delaware, and part of the reason for that was the shareholder vote was deemed to be not fully informed, so it wasn't able to ratify, so they weren't able to blah, blah, blah. But as we just said, Tesla does not need to fear a shareholder vote, a shareholder lawsuit, because they've functionally insulated themselves from lawsuits over conflicts. Right. But the NASDAQ has listing standards. And the NASDAQ listing standards say that if you award a new equity comp package to someone, that needs shareholder approval. So they're going to need, so they can't just, say, well, we're not going to get sued anyway. They actually do need shareholder approval for the comp package.
I was, okay, go ahead, finish. I have a comment.
Oh, no, but the interesting thing, though, is the NASDAQ standard is different from what it be for cleansing, though. Because for cleansing, it's actually technically disinterested shareholder approval.
Yes.
So you would ignore Musk's votes.
Oh, they have so his 13%, I mean, the insider.
Yes. So Musk and his brother get to vote.
Now. Right, yeah, right.
Yeah, they get to, which means there's no question it's going to be approved by shareholders, but they still do need to have the
formality of doing it.
But they do have to have and presumably they don't want the embarrassment of like a bare majority that only got there because Elon Musk voted for his
given
own
the pressure the board's under these days.
Yeah,
and they are under some pressure.
Yeah.
So I had this. I was talking to someone about this that I was wondering. Okay, maybe he wants to be delisted from the NASDAQ because now because once U.S. Steel got the deal with Nippon Steel closed, so there's a certain NYSE ticker that's available now. That U.S. Steel over a century was listed as X.
For it. Yes, the ticker X. You think that he wants to get delisted so he can switch the ticker?
Maybe, yeah. But I'm pretty sure. Oh, I don't know.
I don't know if you can switch ticker. I have no idea what the mechanics are. But if it's free, I wonder if he could just go ask for it.
Free? He would love that. Anyway, but I think to put a point on it is that trying to design and then get the support and so forth for this and to try to overcome these hurdles and getting a comp package together for the guy they could be working until November 5th.
Yeah, no, I think that's what the delay is about. I think the delay is about figuring it out. And they have like both a very real issue hanging over their heads. What is the Delaware Supreme Court going to do? Is it going to affirm? But aside from that, there's just this issue of how do you solve a problem like Elon?
Yeah, right, exactly, and create a comp package and get shareholder approval for it. And that could take, that's not happening in August. Yeah. It's probably going to take until November, so that helps explain it.
Yeah.
So, wow. All right, so we can expect to vote conceivably in November on a bunch of directors, on who the auditor is going to be, whether we like pay, I know I'm voting on all that stuff, and potentially on approving an investment in XAI. They're not going to call a special meeting for that. And then maybe a comp package. It's going to be fun, just like 2024.
Very exciting.
Man.
I am really curious to see what the board comes up with.
Yes, me too. All right, let's why don't we close this up here, right? Is that okay? Can we do that?
Okay.
All right, let's wrap up. It's talk. We'll have to come back to Tesla again soon once they make more announcements. We'll do another pod on that. But for now, we know when the meeting is and what maybe we'll be voting on. So we'll talk then. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann is the incoming professor of law and Lawrence W. Demuth Chair of Business Law at the University of Colorado Law School. I love saying it. I have to remember that now. You can find me, Mike, at theactivistinvestor.com and Ann at new website, LawWeb. One word, LAWWEB, lawweb.colorado.edu, where her new professor page is. Our podcast is produced and distributed by Free Float Media. Thanks for listening. We'll talk again soon.